Hearing court is now in session. The Honorable Judge Sonia Brown is presiding. Good morning, everyone. Please be seated. Are you all ready? If you need some. Yes, we're good. Okay. Thank you, Judge.
Good morning, everyone. I am Judge Sonia Brown. I am the presiding judge for this bench trial, the state of Georgia versus Matthew Scott Lanz, 229000922. We are present here in the open courtroom. Present of the court, the clerk, the court reporter, Mr. Lanz is represented by Attorney Jimmy Berry, and the state is represented by Assistant District Attorneys Green and Horowitz. Good morning, everyone.
Good morning, Judge.
Great. So, couple of procedural matters I do have, which I'd like to give you all copies of the verdict form. So, Madam Clerk, if you could hand that to both the state and the defense so that they can review that for the court. Oh. You'll have a chance to review it. I just want to give you all a copy to review. You can keep that copy.
Okay, thank you, Judge.
All right, and yesterday, before we adjourned for the day, the state did rest on their case, and so, Mr. Berry, I will allow the defense to proceed.
Thank you, Judge. I have spoken with Matthew about whether he would wish to testify. It's his wish to not testify. No, the court is going to ask him
Yes.
about that. At this point, he does not want to testify.
Okay, thank you, Mr. Berry. There are a few questions that I would like to ask Mr. Lanz to inquire about his decision on whether he wants to testify or not. And so, Mr. Lanz, if you raise your right hand for the court, please, sir. Do you swear or affirm that the testimony you will give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
No comment.
Okay, can you put your right hand down for me? Mr. Lanz, do you understand that you have the right to testify, and if you want to testify, that no one can prevent you from doing so?
No comment.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to?
No comment.
Do you understand that you and not your lawyer must personally decide whether you will testify or not?
No comment.
Do you understand that if you do not testify, then upon your request, the court will not use your decision against you?
No comment.
Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorney?
No comment.
Do you personally want to testify or not?
No, no comment.
Attorney Berry, do you stand in your place as an officer of this court, as well as Mr. Lanz's representative, that you have spoken to Mr. Lanz, that you have presented him with the option of whether or not he has the right, or he has the right to testify or not, and all of the issues or concerns with whether he does or does not testify, and also informed him that if he chooses to not testify, then the court will not hold that against him. But if he were to choose to testify, then he would be examined by you as well as the assistant district attorney. Have you spoken with Mr. Lanz and discussed all of this with him?
I have, Judge, and it's his wish not to testify.
Right. Thank you. Are there any witnesses that the defense wishes to call?
No, Your Honor.
Okay.
That's rest.
All right. Can I have the attorney's approach? All right, before we move into closing arguments, are there any other issues or concerns that we need to deal with?
Just for the record, I think that we would need to go to the directed verdict based on
All right, having heard the evidence has been presented here, the court is going to deny the directed verdict if there is enough evidence, at least for the court to consider and the judgment in each of the counts that have been presented before the court.
I believe this is unnecessary.
Right, so state, or do you intend to do an open and close, or are you going to waive openings as far as the closing arguments are concerned?
Yes, Your Honor, we will waive the opening and just reserve closing.
Okay, thank you. Attorney Barrett?
Thank you, Your Honor. Your Honor, I'm not going to belabor too much the evidence, but there are some concerns that the defense has, and I'd like to go over those with the court. And I think it's important to let the court know in the statements that Scott and Teresa Lanz made and the telephone calls that the state through the Celebrate found. I think it's important to know that Mr. Lanz, Scott Lanz, was residing in Washington because he worked there. I think that was brought out. And he had called his son the night before, called Matthew. Matthew indicated that he would be coming home. He did not come home, according to Teresa Lanz. And because of the fact that he didn't come home, like her husband told him told her that he might.
Sorry, I'm having a little difficulty hearing you, Mr. Bailey.
I'm sorry.
I'm having a little difficulty hearing you.
I'll move this over.
Appreciate it, thank you.
Because of the fact that Matthew did not arrive, she became concerned again calling. And because of the fact that he did not respond, she and her daughter both began to call and were not able to get a hold of Matthew. I wanted to make it clear that there was nothing said concerning the fact that she believed that he had committed these crimes. She went there because of the fact that she felt that she needed to do a safety check on him. She hadn't been able to get a hold of her. So I wanted to make that clear in the beginning. We'll start with the crime scene. When the officers came to the crime scene, the first thing that they noticed, of course, after Mr. Hicks, the father, had noticed the back window being broken out. The officer came, and I remember seeing on the video that he took his baton and broke out a good bit of the window. There was a lot of jagged pieces still in the window. I questioned him about the area that he would have to climb through. He said, well, I have on a jacket, so I felt it might be unsafe to try to get him without knocking over the glass. I think that becomes important because you can see the size of Matthew. He would have had to step over that area and not be cut from the glass. Didn't attempt to knock out any more of the glass, so it would have been difficult to get in that window without either cutting yourself without breaking some more of the window out. When they got into the residence, the items that were collected were the 3 shell casings. The officers looked for footprints, fingerprints, all manner of trace evidence. None of the trace evidence was found. They didn't find anything that would tie Matthew to being inside that house. As a matter of fact, the report heard the shell casings were tested, and there was no DNA of Matthew found on the shell casings. So nothing that was found at the scene would tie Matthew to the interior of that same. Matter of fact, the only DNA that came off the shells was the child, Jacob's, which we could see that most of those shell casings were probably moved around by him. We saw in the bathroom that the toilet seat was up, there was some toilet paper on the floor, and it appeared to have other items there. When I asked the officer if it possible that he could have flushed those shells down the toilet, the officer indicated that might be possible. Shell casings were never found in Athens or any other place. So as far as count 13, I don't think the state has carried their burden on proving that those shell casings were taken from the home. The next area of concern, of course, is the firearm. It does have Matthew's DNA on it. It's a little confusing, the manner in which the gun came to be in the possession of the father. He indicated to the police that the clip for that gun and the gun itself were in the coat pocket, and they did retrieve it, but there was no testimony that I can remember whether there was a clip inside the gun at the time that it was collected. So I'm not sure whether there was a clip ever found in the gun or not, or whether that clip actually fit into the gun. That becomes important because the state wants to try to tie the clip that they found in Athens that had, I think, 5 shells missing. Of course, Matthew in his statement indicated that he had been to the range and fired the gun, but they did not pinpoint exactly when that would have been, or where he had gone to the range, and they had been able to find out as they asked that information whether in fact he had or not. The bullets were the SIG 9mm. When I asked the officer, he said those were very common, 49mm. The next item that we're concerned about is Detective Smith's testimony about the headlight signatures. He indicated this V signature that he saw. Questioning about the signature, he did not know what kind of vehicle that Matthew Lanz had. He said, I don't know what kind it was. I was only concerned with whether that particular vehicle fit what I saw on the road. So he was not able to testify that all 2008 Lexus would have that same V signature, or whether there's any other vehicles that might have that V signature, not just that particular. It's not like a fingerprint. It's a V signature from the headlights. We don't know how many other cars there may be that has that particular type of V. The other area that Detective Smith talked about was the floodlights that he saw coming on and going off. And as he testified, at 9:31, the back floodlights came on. They came on again at 9:55, and again at 10:08. We found through the Celebrex that Ms. Hicks had been on her phone at 9:59, which is about 4 minutes after the back floodlights had come on. We don't know much about those back floodlights because nobody tested to see how long they would stay on or what range they had when they did come on, which is very important because if in fact they are saying that the person went in at 10:08, we don't have anybody coming out after that. If they went in to the house at 9:55, they would have had to have been in the house for 4 minutes in order for the sheriff to use the telephone. So that wouldn't really make a whole lot of sense. So there's the question, did somebody go into the house earlier in the day and was laying in wait for them to get into the house and get comfortable before they made their move? So it's an interesting question, especially the fact that you don't see any corresponding exit floodlights, because any movement either in or out should show. It's interesting also that the car that they're indicating was Matthews passed by a neighbor down the street at 10:11:32, which is about 1.5 minutes from the 10:08 going into the home, which meant that a person would have to get in, knock the window out, step over a gate, which the gate was up, apparently. You can see that the gate was pushed from the living room back rather than being pushed from where the person came in forward to be able to get to where the shots were fired. So how would a person accomplish that? Get back out of the house, get to the car in a minute and a half. It's pretty difficult to be able to do that. We know that there was a lot of glass that was knocked out. We asked about the clothing that Matthew had on. There was no glass shards found in any of his clothing. There was no glass shards found in his vehicle. We don't know whether the shoes that he was wearing or what he was wearing supposedly the night before. We do know that he had to walk a mile or so, maybe 2, to get to the home in Sandy Springs that he was ultimately arrested. We don't know whether he picked up any glass shards on that trip from where he left his car. And we don't know whether these glass shards would match with the glass, double pane glass that was apparently there at the Hicks home. So there was no comparison of the glass shards to see whether or not they might be similar or the same, or whether it was pieces of glass that came out of a car window on the side of the road. So we don't have any other glass shards that had been found. And the state made a point to indicate that he had put his phone on airplane mode to avoid people knowing where he was. That wasn't done until 10:15. Doesn't make much sense if you don't want people to know where you're going, then why not put it on airplane mode when he was going there rather than when he was leaving? Doesn't really make a whole lot of sense. What's concerning too is that if you break one of those panes of glass out, obviously, I asked the officers to make rotten knuckles. They also had a dog that, of course, heard in the video that went crazy when the officer came in. With the knocking out of the glass and the dog barking and the light coming on, apparently Mr. Hicks didn't have enough time but to stand up, which doesn't make a whole lot of sense either, which might be something to consider, whether somebody could have come into the home at an earlier time and laid in wait. We can simply ask the court to look at all the evidence in the case. I know the court will. And to evaluate that evidence and testimony and to render a verdict that speaks the truth. That's all that we can ask. Thank you, Dave.
Thank you, Attorney Barry. Okay, Green, you may proceed with the state's closing arguments.
Your Honor, most Americans these days have iPhones. And one of the reasons that iPhones are so popular is because it has the feature of memories. This is what the memories may have popped up looking like on Amber's phone back in October of 2021. But November 18th of 2021, Tuesday of this past week, 4 years to the day, this is what those memories would look like.
Hey, baby, how are you? Oh, okay, come here. Come here. Hey, how are you? Come here. Come here. Come here. Come here. I won't put this in real quick. Yeah, I'll brush it. Come here. Come here. Come here. Come here.
That was the Hicks' home sweet home. The home that they moved into on September 5th, 2021, believing that they were moving into their dream home. This defendant on November 17th of 2021 shattered those dreams and shattered little Jacob's world forever. This is State of Georgia versus Matthew Lanz. Your Honor, we're here before you with 13 counts of this indictment, each of which we will go through. The defendant is charged with malice murder, felony murder, home invasion, aggravated assault, possession of firearm during commission of a felony, cruelty to children in the second degree, and tampering with evidence. But this case is best told by looking at the timeline. So I want to go back through that timeline, starting on November 17th of 2021. We started this trial on November 17th of 2025, 4 years later. If you go back in time, this is what happened on November 17th of 2021. 7:09 p.m., Justin, Amber, and Jacob arrived home. You remember the testimony that Amber had to send her car to a mechanic shop, that Justin picked Amber up, and that Jacob was with them. At 7:09 p.m., this is the last known footage of the three of them alive together. Unknown to Amber and Justin, their killer was en route. By 5:57 p.m., we know the defendant was driving from Athens to the Marietta area or Akron. We know that because on his phone, there's a 1 minute and 58-second phone call with his father. And if you remember, his father stated to law enforcement that the defendant called him and was at a gas station heading home on November 17th of 2021. At 9:20 p.m., Lanz drives down Verbena in his 2008 Lexus GS and enters his driveway. Here's a video clip showing as his car drives down the street. We know that's his vehicle because of the headlight comparison or the headlight signature. He then pulls down Verbena and enters his driveway, which is also located on Verbena. Now it's very difficult to see in that region, but you'll see some flashing light ever so subtly in that area that's circled in yellow. And that's when his car is pulling into his driveway. And again, we know this because there was 2 SUVs that followed behind that proceed and pass that camera at 5050 Verbena. We then know not between 9:31 p.m. and 9:32 p.m., Lanz is walking around the rear and side of the Hicks' residence. We can see that the side floodlights illuminate, and then we can see the infrared camera being illuminated as well as he gets close to that side door. We know at 9:32 p.m. he then proceeds back towards his residence. This is the one camera view that's slightly better, where you actually can see him walking along the roadway back in the direction of his family's home. Between 9:43 and 9:44 p.m., you can again see an individual walking towards the Lanz's property. Now here it's much more difficult to see because of that reflection, but you'll see movement proceed until about this area here, at which point he seems to return back towards his residence. And then at 9:55 p.m., Lanz triggers the side lights again, this time to carry out these executions. You can see movement and shadows reflecting from that light. The floodlights have gone off by 9:59 p.m., indicating that Lanz is now lying in wait in this porch area. But we know that Amber's still alive. We know that at 9:59 and 37 seconds, she loves the comment by her friend, LOL IDKY, but I'm craving it. And she loves the next comment at 9:59 and 40 seconds. Olive Garden it is. At 10:10 p.m., we know that these executions are done. Sometime in that 10-minute window, Lanz executes Amber and Justin, who are completely unaware and defenseless, on their couch in their locked and secured home that they have just purchased 73 days prior. And then he leaves. Just like that. The floodlights come on. He walks towards his residence. and it's over. All with little Jacob alone in his crib. Lanz's vehicle is then captured at 10:11 p.m. As he leaves out Delphinium onto Bellsbury, and then he drives all the way back to Athens, an almost 2-hour drive. And during that time, he puts his phone in airplane mode. It is not a coincidence that his phone is in airplane mode in approximately the same amount of time it would have taken for him to get back to his apartment in Athens. He puts his phone in airplane mode at 10:16 p.m. and he takes it off of airplane mode at 12:43 a.m. November 18th of 2021, the day after the murder. 9:34 a.m. This is the call that's made.
I want to confirm that you guys have called them on their phones and they didn't answer.
We tried calling multiple times now. My brother's phone rings a few times that we're going to voicemail. My sister-in-law's phone immediately goes to voicemail. According to my mother, they've been off social media for about 12 hours now.
Okay.
That call was placed by Ashley Hicks. They had gone to the residence because it was extremely unusual for Amber to just not show up to work. So unusual that her employer had already called both her father and her father-in-law. Within 10 minutes, police arrive on scene at 9:43 a.m. And of course, immediately upon arriving to the scene, they make entry and they find that Amber and Justin have been executed and they're lying in their blood on the couch. Within 1 hour and 40 minutes of police's initial arrival on scene, before police have even made entry into the home, before police have even confirmed that Amber and Justin are deceased, Scott and Teresa are calling their son. So that 1 hour and 40-minute period is really much shorter because Scott and Teresa wouldn't have known what the police knew immediately, and they certainly wouldn't have known before police ever even made entry into the home or laid eyes on Amber and Justin. So that 1 hour and 40 minutes is probably closer to an hour, perhaps less. And they're immediately calling their son because they know he did it before any details or any facts had been released to the public. That is their first thought. The neighbors are done, our son must have done it. They knew what happened in this case before any law enforcement ever knew they existed. Teresa Lanz is so concerned that she drives all the way to Athens to lay eyes on her son and confront him about these murders. Keep in mind, it takes almost 2 hours to get to Athens. That first phone call that they make to him is at 11:24 a.m. and within 30 to 45 minutes of that first call, Teresa's already getting in her car. Whatever she had planned for the day, whatever she had going on was not as important as laying eyes on her child because she knew as a mother, having motherly instinct, that her son committed these murders. She arrives in Athens at 2:14 p.m. We know this because she tells law enforcement she calls when she gets there. She's banging on the door so hard that this defendant thinks that she might actually break the lock off the door or the chain off the door because she's that upset and that concerned. Teresa goes in the home and she finds the murder weapon. Now, of course, she doesn't know that's the murder weapon initially, but she sees the gun. She sees it by his bedside table on the floor. She described that there was 2 magazines. She said one was in it, well, not really all the way, but it was hanging out of it. and the other one was next to it. That is how the gun was initially found. Next to his bedside table with 2 magazines, one of which was in the gun. And we know from the evidence in this case that the one in the gun would have been the one with only 12 bullets in it. Ultimately, even though the defendant doesn't want to relinquish his firearm to his family, he does, once his dad gets there. His dad that had been in DC and traveled all the way home and got picked up by his daughter and drove straight from the airport all the way to Athens to be a part of this conversation. His father took the gun but left behind the magazines, which the defendant then tells law enforcement are inside his desk drawer. November 19th of 2021, 32 hours after these murders, at about 7 a.m., perhaps a little bit earlier, he travels back to Atlanta again. He travels back to Atlanta again. This time, he ditches his car around 5665 New Northside Drive, which is in Sandy Springs. And you can see from the map there that this is just off the highway. I mean, this is just coming off the ramp from 285. Now, ultimately, this dispatch about the burglary comes in at 8:45 a.m. So we know that whenever he leaves the car, it's a little bit earlier than this, which is why it was probably a little bit earlier when he left Athens, probably sometime in the 6 o'clock hour. We also know from when the search warrant was executed on his vehicle that there wasn't really any gas in the car at all. In all likelihood, his car ran out of gas. So was this where he was planning to go? We don't know. Or was it that he was taking 285 from 316 to 85 to 285 to 75 to get back to his residence? Or maybe go look at what's going on at the Hicks' residence. We don't know. But certainly this is on the way back towards Ackworth. But he ran out of gas. So he leaves his car, he cuts through the woods, and he ends up in someone else's home at 90 Cameron Glen Drive in Sandy Springs. And that's when the dispatch call was made for Sandy Springs officers to respond, around 8:45 in the morning. By 6 p.m., with the assistance of Sandy Springs, the dominoes then fall into place. The pieces are then put together, and that is when everyone learns that Matthew Lanz was responsible for these 2 murders. Now, there's 2 checklists that I always like to go through in criminal cases, because it really boils down to 2 things. Number 1, were these crimes committed? And number 2, did the defendant do it? Those are the 2 things we're really looking at. And of course, Your Honor knows better than anyone that the state has to prove each element of each offense beyond a reasonable doubt, and we have to prove beyond a reasonable doubt that this defendant was the one who committed those crimes. So I want to start with the checklist of the crimes themselves, starting with malice murder. Of course, Your Honor knows that the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. Malice aforethought is simply the unlawful intent to kill. So how have we proven malice in this case? How has the state proven that this defendant had an unlawful intent to kill Amber and Justin Hicks? Of course, we can look at both a deliberate intention to unlawfully take the lives of another, and we can look where there's no significant provocation and all of the circumstances show an abandoned and malignant heart. Your Honor, this is so malicious that we have both types of malice. This is implied malice and this is express malice all day long. Executing a couple who is watching TV in the comfort and safety of their own home is as malicious as it gets. If this here isn't malice, then malice doesn't exist. If that is not malice, malice does not exist. Now, while premeditation is not required, we certainly have it here. Lanz arrived at 9:20 p.m. and he executed Amber and Justin at 10 o'clock. 40 minutes thinking, contemplating, stalking. Count one. Did unlawfully with malice aforethought cause the death of Timothy Hicks, a human being, by shooting Timothy Hicks with a firearm. And count two. Did unlawfully with malice aforethought cause the death of Amber Hicks, a human being, by shooting Amber Hicks with a firearm. The malice is there, Your Honor. This is the timeline showing the malice. He arrives at 9:20 p.m. Between 9:31 and 9:32 p.m., he is creeping around the Hicks's back and side yard. Between 9:43 and 9:44, he is again creeping around the Hicks's residence. At 9:55, he makes entry into their backyard and proceeds to sit there and watch at those Christmas lights, waiting until the time was right in his mind to break the window and immediately execute them so fast that they didn't even have time to respond. By 10:10, he's leaving the Hicks's residence. 10:11, he heads back to Athens. And 10:16 to 12:43, he has his phone in airplane mode. This is proof of malice. He had so much time to think about what he was going to do, and he still did it. You had 3 9mm casings recovered on scene and 2 projectiles. You have 5 total gunshot wounds. These gunshot wounds are consistent with the 2 of them sitting there on the couch, again in the comfort of their own home, watching TV. And when Justin heard that window smash, he got up and started peering around to see who was breaking into his home. And as he's peering around and looking, he gets shot here in his side, and it comes out his stomach and ultimately hits the ground. He then starts coiling as Matthew Lanz is continuing to approach on him. He gets shot in the right arm and then gets shot in the back of the head right here and crumbles because he would have never moved again. He got up to see what was going on, but he didn't even have a chance. Guns all in their home to defend his baby and to defend his wife, and he didn't even get a chance. And Amber, she certainly didn't get a chance. She still has the blanket tucked under her foot. And you heard the doctor testify that it was consistent with her being crouched like this. The gunshot goes into her forearm, out of her forearm, into her thigh, out of her thigh, and stops at her stomach. And in order to get that headshot, where it has an angle, it has a clear angle, she's probably like this, closing her eyes, not wanting to look. And he just executes her. He shoots both of them in the head. You have 2 projectiles that were found in Justin's body. One from his head, where he had his head turned because he had started to coil, and it stops at the other side of his head. And then one from his chest, because the gunshot wound that went in his right shoulder stopped on the left side of his chest. You had a projectile in Amber's neck from the shot that went in here and stopped at her neck. He talks about he almost got brainstemmed. Well, he brainstemmed Amber. And I think he wished it worked on him. 5 total projectiles were recovered. We know there were 5 gunshots. He executed them. I mean, he shot them both in their heads in the comfort of their home. And then he kept the gun, he kept the magazine, he kept the rounds, and he just put it in his desk drawer. It was just going to go about his time. He stalked, he waited, he hunted, he drove almost 4 hours total to execute 2 innocent human beings, a mother and a father. That is malice murder. And the state has proven malice murder beyond reasonable doubt. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. Of course, the underlying felony charges here are home invasion and aggravated assault. For home invasion, as Your Honor knows, the state has to prove the defendant without authority and with the intent to commit a forcible felony therein. Of course, here we're talking about aggravated assault. And while in the possession of a deadly weapon or a firearm, he enters the dwelling house of another while it's occupied by any persons with authority to be present therein. The language of the indictment reads, did unlawfully without authority and with intent to commit the forcible felony therein, to wit, murder and aggravated assault, while in possession of a firearm, to wit, a handgun, a deadly weapon, enter the dwelling house of another, to wit, the Hicks residence located at 5059 Verbena Drive, Acworth, Georgia, while it was occupied by Timothy Justin Hicks, Amber Hicks, and Jacob Hicks, persons with authority to be present therein. And then the corresponding felony murder count reads, while in the commission of a felony, to wit, home invasion as set forth in count 7 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. In count 4, while in the commission of a felony, to wit, home invasion as set forth in count 7 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Your Honor, this is a home invasion. There was forced entry into this home. It was without authority. The defendant was armed with a firearm. We know this because he had a firearm. He killed Justin and Amber with a firearm. He had the intent to commit these forcible felonies of aggravated assault and malice murder because he sat there and thought about it over and over and over until he felt like the time was right. That's exactly what he set out to do. It is exactly what he did do, and then he fled. The state has proven felony murder and home invasion. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. This defendant shot Amber and Justin multiple times using his Zev Technologies OZ9 firearm. That's an aggravated assault. Count 8 reads, did make an assault upon the person of Timothy Hicks with a firearm, a deadly weapon, to wit, a handgun. Count 5 is the corresponding felony murder count, while in the commission of a felony, to wit, aggravated assault, as set forth in count 8 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. Count 9 is the aggravated assault count with respect to Amber Hicks, did make an assault upon the person of Amber Hicks with a firearm, a deadly weapon, to wit, a handgun. And the corresponding felony murder count, while in the commission of a felony, to wit, aggravated assault, as set forth in count 9 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Here is the evidence of the aggravated assault and felony murder. It was his Zev OZ9 firearm, 5 rounds fired into Justin and Amber's body. We have 9 total holes within their bodies. 9 total holes, 5 gunshots, but 9 total holes that this defendant put into their bodies. We've proven aggravated assault and felony murder. Possession of firearm during commission of a felony, as Your Honor knows, the state has to prove the person has on or within arm's reach of his person a firearm during the commission of any crime against or involving the person of another, which is a felony. The way it's charged here, we have murder, aggravated assault, and cruelty to children in the second degree, which are felony crimes. For count 10, did unlawfully have on and within arm's reach of his person a firearm, to wit, a handgun during the commission of murder, home invasion, and aggravated assault, felony crimes involving the person of Timothy Hicks. Count 11, did unlawfully have on and within arm's reach of his person a firearm, to wit, a handgun during the crimes of murder, home invasion, and aggravated assault, felony crimes involving the person of Amber Hicks. Your Honor, you have the gun in front of you. This is the gun that took the lives of Justin and Amber Hicks. It's his gun. He possessed it. He brought it into their home. He is guilty of possession of firearm during commission of a felony. Cruelty to children in the second degree. The state must prove that the defendant caused cruel or excessive mental or physical pain to a child under 18 through criminal negligence. Criminal negligence is an act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the act. Executing a mother and father in a home that is filled with baby toys, baby gates, baby locks, a baby monitor right next to his mother's hand, and you sit there and you shoot that mother in the head, absolutely shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the act. Any human being knows that slaughtering two parents in a home with a child creates a reckless disregard for the safety of that child. Your Honor, that is common sense. The way the indictment reads on count 12 is that this defendant did, with criminal negligence, cause Jacob Hicks, a child under the age of 18 years, cruel and excessive physical and mental pain by leaving Jacob Hicks's deceased parents inside the home with said child, resulting in the 2-year-old child being alone and unsupervised for approximately 12 hours, during which Jacob Hicks was unable to feed himself, unable to change his diaper, or get the attention of his parents, causing him excessive physical and mental pain. Your Honor, Jacob cuddled with his dead parents. He cuddled with his dead parents. They were dead in his house. He came down the stairs and he crawled in their laps. We know this because there is blood all over his little Mickey Mouse pajamas. It is on the front, it is on the back, it is under the arms of his shirt. It is impossible to get that amount of blood and in those locations without having cuddled and crawled on his parents, desperately trying to get his parents to acknowledge him, not understanding why they wouldn't. He brought his parents toys, trying to get their attention, putting a plane on his daddy's lap, a plane that could not have been there until Jacob came downstairs, bringing his mom a ball, bringing her a monster truck, doing everything he could to get them to wake up and pay attention. Because in a child's eyes, in a 2-year-old's eyes, the world is all about them. And when they wake up in the morning, it's all about them. Let's start the day. The first place any child goes when they wake up is to their mom and dad. That's what Jacob did. And when he couldn't get their attention, he started bringing them toys. He played with the very bullet that robbed him of his mother, that robbed him of his father. Because there is no way that that projectile would have landed there but for Jacob picking it up. How do we know this? We know this because we have 5 projectiles. 3 of them were recovered at the medical examiner's office. So 2 of them were left on scene. One of them, if you recall, was right in between Amber's side and her arm, which was likely that bullet that went through her, was the bullet that went through her forearm into her thigh and stopped at her stomach. Because that's the only bullet that didn't remain in her body. The other one went into her head and stopped at her neck. Justin had 2 gunshot wounds, both of which the projectile was still in his body and was recovered by the ME's office. The only other projectile was the one that went in his side, out his stomach, and hit the floorboard right next to Jacob's little fire truck that he was driving around the house that morning. He picked it up and he moved it. He played with it. Why? Because it's shiny and it's new, and he's never seen this thing in his house. He was literally playing with the bullet that killed his parents. And carrying glass around the house, because you have a massive shard of glass right next to this projectile, a shard that could have not possibly stayed on the defendant's clothes when he broke through the window, but that Jacob would have picked up and played with. Because once again, in a child's eyes, these are new items in the home that any child wants to explore. He didn't have any way to feed himself. He didn't have any water. He had an extremely soiled and sagging diaper that you can see on all the body cameras. And again, the most traumatic of all of this is that there's hours of trying but failing to get the love and attention of his parents. Now, we have no way of knowing what time he may have gone downstairs. We don't know if he woke up after hearing those gunshots and came down the stairs and then cuddled up to sleep on the couch with his parents, or whether he didn't come down until the next morning. But what we do know is the very latest possible time that he was awake and downstairs was 6:16 a.m. We know that because Justin's phone activity sensor log that's been presented as evidence. And we know that the timestamps on that are accurate because if you recall, at 7:07 p.m., there's logged activity from Justin's device, and we see him physically getting out of the vehicle at his residence for the last time. We also know because if you look further back in that data that's been tendered as evidence, you see that Justin was extremely active throughout the day. And you heard from Tim Hicks that he was at home on baby duty that day. It was his day off. Thank God he spent his last day with his baby at home. But we know at 6:16 a.m. Jacob is now touching that phone and carrying it around the house. And I highly doubt that when he came downstairs, the first thing he did was take the phone. This was probably after he had been trying to get his parents' attention and family. We also know that Jacob took that phone and moved it around the house because ultimately where it was found was on that baby gate, which had been knocked over by the defendant, happened to be right next to his toy ambulance that Jacob also placed there. He even pulled the glasses off his mom and dad's faces, not understanding why they would not respond. Amber's glasses would not have fallen off her face like this, getting shot in the head. It just wouldn't have happened. And we know she was awake because at 9:59 she's loving comments in her girl's text thread. So it's not like she had fallen asleep and somehow they fell off her face. Jacob climbed on his mom and literally took the glasses off of her face to get her attention. 2-year-old children only care about their parents' attention. It's the only thing in the world that really matters to them. And he was so desperate for attention that he climbed on her lap and is touching her face, desperate for her to open her eyes because of what that defendant did. And then when law enforcement comes in the house, there's Jacob, and he now has his daddy's glasses. And you heard from Tim Hicks that he wore glasses when he watched TV at night, and Jacob has pulled the glasses off his daddy's face too. Even the defendant expressed remorse for this. He didn't care about the fact that Justin and Amber were killed. But when it came to Jacob, and when it came to him believing Amber was pregnant as well, he cared. He cared then, and he recognized that that was messed up. He recognized that that's as cruel gets. And that's the only thing he felt bad about. He himself knows that he is guilty of cruelty to children in the second degree. Finally, tampering with evidence, the state must prove that the defendant, with the intent to prevent the apprehension of himself or obstruct the prosecution of himself, he knowingly conceals physical evidence. Count 13 reads as follows: did knowingly conceal physical evidence, to which shell casings, said evidence involving the prosecution of the offenses of murder, home invasion, and aggravated assault, with intent to prevent the apprehension of and obstruct the prosecution of said accused, to which said accused did remove shell casings from the murder scene so as to avoid apprehension and otherwise obstruct the prosecution of himself. These officers tore this house apart. I mean, they tore this house apart. They looked in every single nook and cranny. They moved furniture. They moved the rug. They did everything to locate those casings, and they did. There were 3 casings found, and that was it. Now, why he didn't take the time to get the other ones, maybe he got spooked. Maybe the dog started barking at him. Maybe Jacob came downstairs. We don't know. But he decided he needed to get out of there. So he only took the 2. But he is guilty of tampering with evidence. We don't have to prove what he did with those items. We don't have to prove if he threw them out the window or whatever he did with them. So taking a pause here, are the crimes themselves really in dispute? They're not. They're not. I mean, the crimes occurred. We all agree the crimes occurred. Even the defendant agrees the crimes occurred.
Why does he murder them? Someone murdered them. What did I say?
He said somebody murdered them, obviously. And they're like, okay, well, you murdered him, Mr. Lanz. He goes, I don't know what you want me to say. Whether or not he wants to admit he did it, he recognizes that somebody committed all of these crimes. And so the only real issue is, did this defendant do it? We know the crimes occurred. Did this defendant do it? We told you at the beginning, Your Honor, that there were three main pieces of evidence we wanted you to consider. That was the digital evidence, the statements, and the forensic evidence. Now, one thing we do not want you to consider regarding his guilt or innocence of these charges is his brother's past behavior, his own past behavior, or his subsequent behavior. And I want to explain that. Your Honor knows better than anyone that you are here to consider the evidence concerning these crimes in this bill of indictment and not past acts or subsequent acts. The only reason that those instances were even mentioned during this trial is because they were inextricably intertwined with this case itself. The only reason we ended up being able to really solve this case when we solved it is because of Sandy Springs. Because when Sandy Springs conducted their investigation and they realized his parents lived right next to the Hicks' residence where there was an open double homicide investigation taking place, they reached out to Cobb County. You heard during the interviews, everything is inextricably intertwined such that you can't even separate the two. The only reason that his brothers mentioned is really through the defendant himself. And talking about his brother and talking about the fact that he still thinks that those residents at 5059 were in some way terrorizing him or something along those lines. But we want to make it clear that in no way, shape, or form are we trying to argue propensity or bad character or anything else, because the reality is there is no propensity here. We are not saying there is any form of propensity here at all. These crimes should be considered as an isolated act that happens to be incredibly evil, with the only possible explanation that this defendant provided is those homeowners used to terrorize my brother, and there were some demonic lights, which came from this defendant as really the only possible motive, as though he's seeking revenge, although he won't say those words himself. So looking at that timeline, again, we know that it's basically just a 10-minute timeline. We know when Justin, Amber, and Jacob arrived home. We know when the rear floodlights were triggered at 9:55. 4 minutes later, Amber sends her last text ever. The rear floodlights are triggered again, and then the delivery is made. Again, this is the last time. Look at Jacob running in the house, so happy to be home with his mommy and daddy. You have the last two text messages, and this is in UTC, the adjusted time, I believe, is on the exhibit there. And then you have the delivery that's made a few minutes later at 10:17 p.m. That's a typo there. But at 10:17 p.m., which we see that notification come through on Justin's watch, which was plugged in his bedside, because it was nighttime and they were watching TV. And then that package that was never obtained. So we know that whoever triggered the floodlights at 9:55 and 10:10 committed these murders. We know that because there's no way someone broke in after 10:10 and did not trigger those floodlights. There's no way that when text conversation continues with Amber's friends and she's just not responding, there's no activity. Justin's phone never moves again until 6:16 a.m. We know that whoever triggered those floodlights at 9:55 and 10:10 committed these murders. The defendant's vehicle was on scene during the precise window of the murder. How do we know? Because we see his vehicle drive down Verbena. We see that his vehicle is the only one that doesn't actually continue past 50-50 Verbena, and instead you see some reflection from where his residence is. We have the headlight signature, which is abundantly clear, particularly in the fleeing the scene immediately after these murders. Watch it again and look at that headlight signature. We have the defendant's firearm. This firearm sitting in front of Your Honor, which was purchased by the defendant, absolutely, positively executed Justin and Amber. We know that. The test-fired projectiles from the ATF matched the projectiles recovered on scene not the projectiles, the casings. The test-fired casings matched the casings recovered on scene. All right, defendant Lanz purchased this firearm 1 month prior. Okay, he had this gun in his possession 1 month prior on October 13th of 2021. And we know it was Matthew Lanz himself who purchased this firearm because they took a copy of his ID. And we have the receipt. He spent almost $2,000 cash buying this gun that he would then execute 2 innocent people with. All of which was unknown to his parents and against their wishes. You heard Scott Lanz, he did not like guns. Not at all. And when they talked about, well, why did you take that gun from him in Athens? Why were you so concerned? He said to police, he was going to shoot himself or someone else. That was this defendant's father's concern. His own father admitted that was a concern, which is why he took the gun from his son on November 18th of 2021. The magazine that held the bullets that pierced Justin and Amber's body was found in the defendant's possession, in which the defendant admitted these were his. One of those, which again is sitting before Your Honor, was missing the precise number of bullets used to carry out these executions. A capacity of 17 bullets in each of these magazines. One of them only had 12, which is the exact number used to kill Justin and Amber. And again, Teresa Lanz admitted that when she first arrived in Athens, that magazine was in the gun. Now, she didn't specify how many bullets were in each magazine, but she specified that one magazine was in the gun and one was lying next to it. The defendant has the exact same type of ammunition that was used to kill Justin and Amber in his possession. And that same type of ammunition was found in the magazines. And you had additional ammunition found in the gun box. The gun box that he had shoved into some bag and then shoved into some storage box. But he also had in his possession. The defendant's DNA was found on the murder weapon. We know this, and that's not a surprise. And Scott Lanz said, yes, my son had that gun. Teresa Lanz said, yes, my son had that gun. They took it from his possession. So it's really not shocking that his DNA is on it. He bought it. We know he possessed it. But he also used it to kill Justin and Amber. Look at his clothing. He had glass in his shoes that were collected from Sandy Springs. And again, why is this Sandy Springs thing important when it comes to the clothing? Well, number one, he had about I mean, just numerous layers of clothing on. And you have those photographs, pants upon pants upon pants, shirt upon shirt upon shirt, multiple layers. He was never gonna cut himself, even if he hit even if he threw himself through that window. He would have never cut himself. Not with the amount of clothing that we know he was wearing 32 hours later. But also important about Sandy Springs is he didn't break glass in that home. There is no broken glass, which makes this shard of glass so important. Had he broken some sort of window or door or lamp or whatever in the home, this would not have been as significant. But there's no glass in Sandy Springs. There's no explanation for why he would have glass shards in his shoes. Another reason that clothing is so important when it comes to Sandy Springs is this lack of GSR evidence. It would have made no difference. Testing his clothes, his hair, his hands, anything would have made no difference because we know he was shot. If he had GSR on his person, on his clothes, on anything, at the point in time that Cobb County learned of him, it would have had zero significance because he had been shot. Which is why it was so important to explain that and explain the sequence of events, to explain this investigation and the findings here. The defendant's cell phone, again, he puts his cell phone into airplane mode as he drove back to Athens. Why? Why do that? Well, the only explanation is because he told his dad, hey dad, I'm coming home. I'm at a gas station. It's 7:57 p.m. and then not showing up. Instead, deciding to execute a mother and father on the couch and then going, I should probably take some steps to cover up. Not only should I take at least the casings I should find, but I should put my phone in airplane mode so they can't get any data off of it. The defendant's statements, he admitted he was on scene that night. That is so, so important. He put himself there. Now, interestingly enough, his timeline that he provides, which is quite precise, is exactly 1 hour off. It's exactly 1 hour off. He says, I got there at 10:30 p.m. and I left at 11:15. Well, no, he got there at 9:20 and left by 10:10. Now, this is November 21st, November 17th of 2021. Not long after daylight savings. So I don't know, maybe he hasn't changed his locks in his car. I don't know. Or maybe he was just being very precise in his timings, but didn't want to give up the fact that he knew exactly when he killed them and needed to adjust his timeline a little bit so it didn't seem like he committed the crime. But either way, it's just so interesting that not only does he put himself there on scene, it's around the right time. And it's for the right amount of time. Because he's ultimately there for 50 minutes. He puts himself there for 45 minutes. Same thing. Now, in his story to police, he says, well, I got so tired when I arrived at my parents' house that I have a key to that I'm just going to drive 2 hours back. I'll take a cat nap in my car for 10 to 15 minutes, then I'll smoke a cigarette, and then I'm just going to drive back because I'm exhausted. I mean, that makes no sense. None whatsoever. He then admitted that there was some sort of bad vibe, which is what caused him to drive all the way back to Athens, never telling his parents he was home, never trying to get in the home, never stepping foot inside his home, and then not wanting to tell his parents he had been there either. I mean, keep in mind, the parents go there immediately and they're like, what have you done? And he's like, I don't know what you're talking about. I didn't kill anyone. I'm here. I'm in Athens, right? But then he tells law enforcement, oh no, I was home for 45 minutes, but I just never went inside. Why lie? When asked, well, if the neighbors were killed, Why would they have been killed? He said it probably had something to do with the demonic lights. You heard that interview. You heard the Sandy Springs portion and the Cobb County portion, because Sandy Springs had already started that conversation. And throughout all of that, he keeps talking about these lights, the flickering lights, the demonic lights. He's fixated on it. And he talks about it over and over. That's the only thing he'll really say as it relates to the Hicks' residence, is the lights. Again, the defendant's parents traveled separately an hour and 45 minutes after hearing of Justin and Amber's death. I mean, this was immediate action on the part of his parents, specifically because they wanted to confront him about whether he committed these murders. Scott Lanz said on scene when they went to the Lanz's residence at 600 Delphinium, and they're talking to Scott Lanz outside, right? He tells law enforcement, Teresa called me about what happened here. The first freaking thing for some reason that came to my mind, and then he trails off. You can't understand the rest of that statement, but you can fill in the blank. Teresa called me about what had happened, and the first freaking thing that came to my mind. That's what this defendant's own father said. And in that same body camera footage, his father says, we tried to have a chat with him, point blank level with us to say, was he involved or was he not? He was very, very, very sketchy. He wouldn't answer. He said, Dad, I didn't murder anybody, but I was not convinced. There was suspicion. His own father did not believe him. During his interview, during Scott Lanz's formal interview with law enforcement, he says if the bullet matches, he's done. Well, the cartridge cases did match. They matched the firearm that Scott Lanz took from him on November 18th of 2021. His parents want to believe that he's sick or mentally ill. You heard his mother say that repeatedly during their interview. Wanting to believe he's insane, and that's reasonable. That is completely reasonable because it is unfathomable to a parent to accept that their child could be so evil. That is unfathomable. But at the end of the day, they still knew what he was capable of and what he did. And Your Honor saw his Google search history. One day before these murders, he is Googling facts about blood and the 10 Commandments. He knows the 10 Commandments. When Detective Jackson asked him about the 9th commandment, he knows. He had been Googling it not 24 hours before. And on October 29th of 2021, he's Googling, do heads really explode as portrayed in Pulp Fiction? Does 308 explode a human head? And then on October 12th of 2021, he is Googling death statistics, total number of fatalities in the United States 2018, mortality in the United States 2019, fast facts from CDC, death and mortality. This was just one day before he bought this gun. One day, and actually it was after he had filled out the 4473. But one day before he became in possession of this firearm that he used to execute a mother and father. So how do we know that this defendant committed all of these crimes beyond a reasonable doubt? It's his vehicle, it's his gun, it's his magazine, it's his ammunition, it's his DNA, it's the demonic lights he keeps talking about. His parents assumed he did it right off the bat. The Freudian slip about the North Face. When they're like, you're probably wearing that same jacket you had on in Sandy Springs because there's some light colored top in the surveillance footage. He goes, oh, no, that's my other North Face. A Freudian slip. He admits being on scene. And then during the transport, he says, I still feel terrible about knowing there was a baby in that woman's body. He's like, is that true? Did she really have a baby in her body? Jacob and this unborn child that law enforcement thought existed at the time was the only thing this defendant cared about. The evidence here is overwhelming. Your Honor, the only demonic thing that night was Matthew Scott Lanz. This defendant acted as only a demon would, breaking into a stranger's home to execute them and leave for no reason. We've spent this week talking about the defendant, talking about his actions, his gun, his ammunition, his DNA, his statements, all of this evidence that proves his guilt beyond a reasonable doubt. But I don't want to lose sight of why we are here. And looking at this case from the eyes of Justin and Amber and Jacob. Victims who should be with us today. Victims who should have been able to come to court and tell this court what happened. To tell this court what they experienced and what they felt. But they don't get that opportunity. They don't get that opportunity because this defendant callously and maliciously and cowardly took their lives, but luckily left behind a home that told a story of exactly what Justin and Amber experienced. September 5th, 2021, just one day after Jacob had turned 2, Amber, Justin, and Jacob moved into Amber's dream home. A home that she believed would be their forever home, that they could continue growing their family in. And they were happy. And life was good. And what made this home a home to Justin and Amber was 3 things: safety, security, and love. After all, that is what makes a home and not just a house. Safety, security, and love. And it's why our legislature includes so many protections when you're inside your own home. It is why the phrase sanctity of your own home exists. Because homes are meant to be a sacred place. Amber and Justin had this sign in their dining room: "As for me and my house, we will serve the Lord." A declaration that their home, made up of Amber, Justin, Jacob, and their pets, their dog and their cat, would follow God. Their home was their domestic place of worship, where they would raise their child and nurture him in faith and love and devotion. These are all the efforts they made to protect their home, to protect their place of their sacred place, their domestic church, putting up all these different surveillance cameras and censored floodlights. And it's a shame that they had only been there for 73 days, so they didn't have a chance to start their subscriptions to save all this video footage. But the sad part of all of that is it wouldn't have changed anything. It would have shown that man's face on them. But that's it. That's it, because they wouldn't have had time to act, because he so quickly broke through that window and executed them. But these are all the measures they took to protect their home. And they did everything to protect their child. Baby gate upon baby gate upon baby gate. A monitor, baby locks on every single door. Because they wanted to create a safe place for Jacob to grow and learn and explore. And what safer place exists in this world than one's own home? Those were all of the efforts they took to protect their baby. And they loved inside that home. They loved and they loved hard. You see it all over that house. You see Bibles. You see in Justin's chair, he had a cushion that was pictures of him and Amber so happy, and a verse out of Corinthians. You see this love letter that Amber wrote Justin the day before on 11/16 of 2021. I want you to know that you are brilliant. I'm so sorry that this did not work out the way you wanted. I'm confident you will do great next time. Please don't be down on yourself. These things happen. I'm so proud of you. You have to do this for you, not for me, not for Jacob, for you. Remember all the studying, all the quizzes you've had to take. You know this stuff and you can do this. Find the confidence. There's no reason to be worried or nervous. I have a video for you to watch. Today is cuddle day. Love you so much, wifey. And you look in little Jacob's bookshelf there and all the books that were in there that you can see based on how they're placed. Oh, the places you'll go, wherever you are, my love will follow. God bless you and good night. These are the books that you can identify from this picture. And I'm sure many of the other ones talked about love and support and raising him in this Christian home filled with love and faith. This was an incredible and perfect family doing everything they could to protect their child, and yet they failed. They failed. And at no fault of their own. As they laid here on this couch for cuddle day, in their dream home, all of their doors locked and secured, the baby monitor on, it wasn't enough. It was not enough. It was not enough to prevent evil that came through that window. Absolutely terrified. Likely frozen in fear, certainly for Amber. Thinking of their sleeping baby who was upstairs and they could do nothing to protect him. Everything they did inside that home was to protect Jacob, and there was nothing they could do. They were unable to go upstairs. They were unable to hug him, grab him, say I love you one last time, shield him from seeing what evil looks like at the age of 2 years old. Nothing. They literally did not stand a chance. And we know, based on Amber's positioning, she died absolutely terrified, which is the worst feeling in the world, particularly when it's in your own home. As she curled up and shut her eyes and looked the other way. And we know that Justin was probably afraid too, and he was thinking of his baby too, but he was the man of the household who was going to get up and see what was going on, but he didn't even have an opportunity to get past the rug because of that man. This is what he left in the home. As though things could not have been worse as is right here where it stops, little Jacob came down the stairs to find his parents. And he found them. And he tried to do what they wish they could have done the night prior. Hug him, love him, lay with him. He got to hug his parents and lay on them and talk to them, but with no response. He tried and he tried and he tried, and he even pulled their glasses off of their faces. The most beautiful faces in the world to him, with absolutely no response. Not his mother's warm, loving body, but a cold, stiff body covered in blood. This was one of the books that you see on his bookshelf. And I don't know if it makes it better or worse to think that this may have been one of the last books that his mom read to him. If someday you're lonely or someday you're sad, just lift up your face, feel the wind in your hair. That's me, my sweet baby. My love is right there. My love will find you wherever you are. It is beyond evil and cruel. So was it even brutal, Mr. Lanz? Was it even brutal? That's what he asked law enforcement. Was it even brutal? Yes, Mr. Lanz, it was as brutal gets. And if you weren't sure that night, you are now. Because you've seen it in the daylight, in an excruciating detail, the damage that you caused. And this little boy, now 6 years old, left without a mom and dad. His last memories, if he even has them, is when he was 2 years old. So he's left with pictures. Pictures, many of which are in the home in which his mommy and his daddy was brutally murdered because of this defendant's choices. Choices that he sat and pondered over for 40 minutes. Your Honor, this case is clear. This defendant is guilty of every single count in this indictment. This defendant really doesn't feel bad for what he did. He doesn't. And he knows what he did. He knows exactly what he did. Which is why he feels like none of this is really necessary. But we are asking, Your Honor, to reach a just verdict and a just decision, which is exactly what the defense is asking for as well. But the only just and true decision in this case is that this defendant committed all of these crimes beyond a reasonable doubt. And we ask that you make those findings.
Before I step off for deliberations, I do want to have the same defense review the evidence that is available to go back with the court for review. If you all would approach me just one moment. All right, I'm going to step off for deliberations. The state and the defense will review the evidence that is allowed for the court to take back for review during deliberations. And Madam Clerk, I'll give it to you for handing to Madam Bailiff to bring back once that's done. All right? So at this time, we will stand in recess for deliberations.
Seven?
Yeah.
Just. Chinese crimes and photo.
on February the 20th, when you, that's when you
The day I
spoke
got
with
arrested?
Jeff, that's the day you got arrested. Jeff Jackson and Agent Lewis and Carter.
Yes, ma'am.
Tell me about that interaction.
So, February 28th, I was with a girl named Trish Evans. She had a house in Camden. So I had stayed the night with her. And that morning I was getting up, I was going to help a guy that owned a local plumbing shop up there. He's not sure his name. I think his last name was Farmer. I was going to help him that morning, and Richard Cottom went by my house and seen there was police everywhere. And I think it was Linda Kimball is the one that called and said, "Hey, there's cops all at your house. What's going on?" So I thought it was the local cops. I thought they had done sold to a confidential informant, sold some drugs or something. I didn't really know what was going on. So I called the Gator County Sheriff's Department. And I said, "Hey, look, what's going on? Why is the police at my house? What are y'all doing?" I said, "Zach, we don't know what's going on. It ain't us." So I called. And I said, "Well, y'all go back by there and see what kind of cops it is." So they went back by, and they said, "Well, it's got to be TBI." So I went on the internet looking for the number for the TBI. They don't really have a number, so I just called 1-800-TBI-FIND. And I asked them, I said, "What are y'all doing in my house?" And they asked, "Well, where are you at?" They wouldn't answer my question. I lied. I said, I'm in Lexington. "What are y'all doing at my house?" They said, "Well, we need to talk to you." And I said, "Well, I'm working right now. Well, you need to get here." And I said, "Well, I don't have a driver's license." So I hung up, took my phone apart, and I called my girlfriend. I said, "TBI's at my house." And I said, "I really don't know what this is about." And she said, "Well, what do you want to do?" And I said, well, I need to go see what this is about. This is, there's lots of law there. So I said, "I'm just going to have them come pick me up. There's no need in you driving." She didn't have no license. And so I called TBI back. I said, "Well, y'all come pick me up at the McDonald's in Camden. I'm leery of police anyway, so I wanted to meet at a public spot." So they came, and I called them back and I asked, I said, how many TBI agents are there? And I think they said 3 or 4. I bought everybody. I went in McDonald's. I bought everybody Sprites and drinks and sausage and biscuits and just I bought everything and got in the vehicle at the McDonald's with Jeff Jackson, and I don't know the other agent's name. I know Jeff Jackson was in the back. We leave McDonald's and they pull right in the Camden Bank parking lot. Tell me to get out. And then the whole time Jeff Jackson's got his hand on his gun. And I'm thinking, when I get in that vehicle, I thought I was going to get shot. I didn't know what was going on. He never took his hand off his gun. They pull me out. They search me. And I'm asking, like, what's this about? What's this about? And they make statements that my brother has made statements. I says, "Dylan, he's in federal holding. What has he made statements about?" When we get to my house, and it's a circus. Like, they had the driveway blocked off. They had the TBI mobile command unit in my granddaddy's front yard. It was a circus. It was a circus. And
So let me just make this, you sought out law enforcement when you found out that they were looking for you, and you invited them to come meet with you.
I did. I called them.
Okay.
All right. His version of the events when he was taken into custody for the murder of Holly Bobo. Coming up, Adams calls his initial defense attorney unorganized and says he wishes he would have testified during his trial. Stay with us.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court, and this week...
I'm Dr. Jason Bull. I study a jury's behavioral patterns.
Just give me more.
Not guilty, thank you. The verdict you get depends on me. You don't get a name like Bull because you give up before the game is over.
We're binge-watching Bull, Sunday starting at 6, 5 Central on Court TV.
We'll head back to Tennessee in just a minute, but first an update out of Georgia, where the judge has sent the jury back, and the jury is now deliberating in the stranger home invasion murder trial. Just started, 21 minutes. Oh, the judge, there's no jury. Remember that? Yes, sorry, my fault. This is a bench trial. The judge is deciding the fate of the defendant. He's thinking about it. 21 minutes so far. They just finished up their closing arguments in that case. It was a heartbreaking case, of course. He's accused of murdering this young couple back in November of 2021 in this random attack. They moved into the neighborhood. He lived with his parents behind them and broke into their house allegedly and shot them both. Let's take a listen now to some of those closings from the state earlier today, describing the Hicks family moving into their dream home.
That was the Hicks' home sweet home. The home that they moved into on September 5th, 2021, believing that they were moving into their dream home. This defendant on November 17th of 2021 shattered those dreams and shattered little Jacob's world forever.
That little boy found covered in blood. He'd been alone 12 hours while his parents were laying dead. Again, this is a bench trial. The judge will determine Lanz's fate. We'll get you into the courtroom as soon as there is a verdict. Now, back to Tennessee, where convicted killer Zach Adams is in court for a post-trial hearing this week. He's trying to get his guilty conviction from 2017 for kidnapping, raping, and killing of Holly Bobo, 20-year-old, overturned. He wants a new trial. During the trial, a man named Jason Autry testified that he witnessed Adams kill Bobo, but now, years later, he says he made all of that up. Adams' defense is now appealing the conviction, as you thought they probably would when someone comes up and says, I made the whole thing up. Let's go back in the courtroom. Let's hear more from Zachary Adams.
All right, so I want to ask you one last set of questions. Okay. At your trial in this case, has your defense always been straight up innocence?
Always. Till my last breath on this earth, it's always going to be innocent.
Then why didn't you testify?
The reason I didn't testify, a week before my trial, Jennifer Thompson had my mom and my cousin come in from Atlanta. My mom had to take off work and come up here, and we all met at the Savannah jail over here in the library. And they had already talked before this and planned all this out, but they got up there, she got my mom up there and my cousin up there, and my mom made me promise that I wouldn't testify because all the bad things that the state was going to try to say about me, and you know, they just didn't want me to testify. And
Did any of your attorneys ever meet with you and prepare testimony for you?
Never.
Did you discuss taking the stand with Ms. Thompson?
I did, multiple times. And she, the way I guess that she practiced, she's tried to say that, you know, she didn't want me to. She didn't want me to at all. Okay. I was advised not to. I wanted to bad.
How about with Mr. Simmons? Did you have that conversation with him?
I didn't, not that I recall.
Okay. Did the pressure from your family and the advice you received from counsel, did that in any way affect your decision not to testify?
It did. It did.
Do you recall Judge McGinley asking you questions, saying, is this your decision not to testify?
He did. He did ask me that. And at the time, I didn't realize I could have said yes, you know, and went against my lawyer. You know, I just was going with what Jennifer, you know, we paid her a lot of money. She was a paid attorney. We paid her a lot of money, and I was told to listen to her. And that's what I did.
Did Ms. Thompson ever sit down and discuss any kind of defense strategy with you?
We met a lot, but like the discovery. I never got to see all the discovery. like, she tried to fix it up at the Williamson County Jail where I could get a computer and get the hard drives, like, and the sheriff, they wasn't trying to make anything extra, like, special for me. He said, no, you can get it mailed in. What the sheriff didn't realize is it would have filled 4 or 5 cells up, and I never got to see all the discovery. I never, you know, we met a lot, but a lot of it was just, you know, she just asking where I was, just, you know, she was unorganized, very unorganized.
So, being a part of this post-conviction relief process, observing Mr. Bates and I.
Day and night difference.
So, knowing now, if you had known then what you know now, would you have testified?
Absolutely.
And I just have to ask these questions one more time. Did you kidnap Holly Bobo?
No.
Did you rape Holly Bobo?
No.
Did you murder Holly Bobo?
No.
Did you have anything to do with the disposal of her remains?
No. And if I would have knew anything about this, it could have helped in any way possible, I would have.
And is everything that you testified today the truth?
Absolutely.
That's all I have, Your Honor.
Thank you, Your Honor. At 8:19 in the morning on April 13th of 2011, you texted Jason Autry.
Okay.
Never mentioned that to the police.
I didn't mention every text I made. I didn't tell them every time I used the bathroom.
8:30, you called Jason Autry on the morning of April 13th, 2011.
Ms. Weiler, there was a lot of phone calls I made that morning. There was a lot of people I talked to that morning that I don't recall talking to.
8:35, on the morning of April 13th, 2011, you called your grandfather, Dick Adams. 8:37 in the morning of April 13th, 2011, you're calling Jason Autry again. Let me guess, you don't remember that, right?
If I would have, I would have.
You would have what?
If I would have remembered, I would tell you. I'm not
Okay.
going to sit here.
Okay. 8:38, Jason Autry calls you back. Again, I'm talking about the morning of April 13th, 2011. The morning that has been your whole life since it happened. Since April 13th, 2011, that day has consumed your life. And nobody until this moment has heard that information. You didn't tell one officer.
I did not.
Wait, I had nothing to do with Holly Bobo's disappearance. I was on the phone with my grandfather. I was texting with my buddy Jason Autry. Never mentioned it.
Okay, the hard part, the cross, is now underway. We'll get a break. Cannon Kearney, your thoughts? How did he do on direct?
On direct, he came off as trustworthy as a criminal can be, Ted. I would say that, you know, you have to take what he said with a grain of salt, but at the same time, he was trying to make himself seem very believable. I mean, drug dealers don't want police officers at their house. Drug dealers would like for police officers not to be in their neighborhood. People who do drugs don't remember every phone call that they made. These are all reasonable things that if you think about, you could find that he's being credible. But then you add in all the other things like the death of Miss Bobo, his inability to recall what's going on to police officers or law enforcement. And you can keep going. So he has a lot in his favor. He has a lot against him. But I think the biggest issue is he's just a criminal, and criminals don't really get to be seen as credible witnesses.
No, you're right. And cross is going to be difficult. Strategy is going to be aggressive. We already know that.
Definitely. She came in with full force. She came in like you're supposed to do on cross, with yes and no answers. The prosecution is there to ensure that the judge doesn't sway, that the judge doesn't hadn't heard what was just said by the witness, and now gets him another bite at the apple. She wants to make certain that her prosecution office is seen as the office that put this man away rightfully.
Yeah, absolutely. Cannon, as always, thank you. Good to see you, sir. We're going to get a break. When we come back, Adams' question on his alleged alibi for the morning of Holly Bobo's murder, and the judge still deliberating. Welcome back to Court TV Live, along with Kelly Craft. I'm Ted Rollins. Good to be with you. We are in Tennessee today, and we're watching this fascinating post-conviction relief hearing for convicted killer Zachary Adams.
Adams was found guilty of kidnapping, raping, and murdering 20-year-old nursing student Holly Bobo. This was back in 2011.
Yeah, but the defense is saying, listen, we need a new trial because the state's investigation was faulty and relied heavily on the testimony of one of the defendants and co-defendants. Adams' brother Dylan and another man, Jason Autry, were also charged in the death, but Autry took this deal, a plea deal, a great deal, in exchange for his testimony against Adams.
Autry has since gone back on what he testified to at trial, saying he made the whole thing up. So why don't we go ahead and get you back into court now? More of the cross-examination of Zachary Adams.
Never mentioned it, did you?
There's a lot of things I did that day that I didn't mention.
Right.
It wasn't because I was lying or trying to be. It's because I just didn't remember. I was a drug user. I didn't remember everything I did that day, but I didn't lie about where I was at.
You like to
Absolutely
leave
did not.
things out, like you told. You like to leave things out sometimes when the police talk to you.
No.
Okay.
No.
8:38, you're calling Jason Autry. 8:53, you're calling Jason Autry. What was the urgency of getting hold of Jason Autry that morning?
We talk all the time.
Okay.
We probably talked every day. Pull the phone records before that day, April 12th, April 11th. How many times did we talk to Jason Autry? I talked to Jason Autry weekly. I mean, every day I've talked to Jason. There probably wasn't a day that went by during that time period that we didn't talk. We used drugs every day. Of course we talked.
Y'all were
Absolutely,
close.
we talked every day.
Y'all were close.
I looked up to him.
Right. 8:58, you get a call from Brandon Williams.
Yes, ma'am.
9:10, you get a call from Brandon Williams.
Yes, ma'am. We was talking. Brandon Williams was a friend of mine and Rebecca's, and yes, I was talking to him. We were trying to get him to help get on my side and get Rebecca back on my side.
Rebecca Earp testified at the trial. Of course, she was not telling the truth, right? She was mistaken about what she remembered. She wasn't telling the truth. She told the jury, you left early that morning to go scrapping. Turns out you didn't go scrapping, right? Remember that?
I didn't. Look at the scrap records. I didn't. I scrapped before. I think it was 2 days before that, and a couple days after that.
She told her that's
where
where
she
you
at my house. If she was if she testified that she was at my house, how is she at my house if her cell phone is pinging at 4 a.m. at her mama's house? How is she at my house?
I don't know.
Somebody's
Between 9:50 and 10:32 in the morning, you're wearing your phone out. You remember that? 9:50 and 10:32 from the Bird Song Tower, which is the closest to the interstate, which is the closest to the underpass, which is the closest to where you put a bullet through the head of Holly Bobo. You are wearing your phone out. Do you remember who all you texted and called? You called Joe's Video. Shane Austin is calling you. You're calling Michael Hughley. Is he one of your drug buddies too?
He is.
Okay. You're calling Joe's Video again. Who works at Joe's Video?
Rebecca Earp.
You called Joe's Video again at 10:15. At 10:15, you're calling your grandfather again, trying to find him. At 10:16, you're calling your grandfather. 10:18, you get a text. 10:18, you send a text. 10:19, Shane Austin is calling saying, where are you, man? Right? Where are you, man? This plan is about to fall apart and blow up. Where are you, man? 10:19, you called Joe's Video again, trying to get a hold of Rebecca because y'all were having a fight, right? 10:35, you call Dick Adams, your grandfather, again. 10:38, you call Rebecca. 10:49, Rebecca texts you, and lo and behold, and the whole world heard it, and there's no denying it, and nobody cares, that at 11:12 in the morning of April 13th, 2011, where were you?
It's at my house.
At 11:12 in the morning on April 13th, 2011?
I don't recall exactly where, I don't recall the exact time. Like I just testified to, the first thing I remember that morning is Shane calling. He asked if we wanted to overdose on Xanaxes. Just like I said, I went out to my brother's, got him up, got on Facebook.
No, you didn't. because there's evidence in the file, and I'm sure you've seen it because your lawyers that are sitting here today have shown it to you, and the lawyers, the 16-member team that you had representing you at trial, they showed you everything. There's no proof that you were on that computer at home. It was a mobile posting from your Facebook page. The last activity was at 6 o'clock in the morning. Is that coming back to you?
That's
At
wrong.
11:12 in the morning of April 13th, 2011, where were you? Let me give you a hint. The bank. Does that sound about right?
I don't recall.
Isn't that what this is all about? Your lawyer stood up months ago and said, our client was at...
We was at the bank.
May I finish? They stood up months ago and told this judge that on April 13th, 2011, the last day that Holly Bobo took breath on this earth, my client could not have committed the crime that a jury convicted him of because he was at the ATM in Parsons. Dun dun dun! Mystery solved. We are so sorry. 11:12 in the morning is the whole point of this hearing, for you to convince Judge Bradbury that there's no way you could have raped, murdered, and kidnapped Holly Bobo because you were pulled in backward at the ATM at 11:12 in the morning on April 13th, right?
That's
Right?
correct. That is correct.
Right.
That's correct.
But we got no proof of that.
That truck.
Okay, the truck that you can't see anybody in.
That truck is my brother's truck. I was driving that truck.
Okay.
Was there any other vehicles that was pulled in the ATM backwards that day?
I don't know. Couldn't tell you.
If we had the real ATM video, we would know, wouldn't we?
We've seen it.
That's not the real ATM video. ATM video shows the person that's punching the numbers in. If we had that, we would see Shane Austin punching the numbers in,
And here's,
and you would see me in the driver's seat, and possibly my brother in the back.
you know what the jury heard from your cell phone expert? Do you know what the jury that convicted you heard from your cell phone expert? Not the state of Tennessee's, though he agreed with it, but from the very expert. You remember Jonathan Reeves? Remember that name?
I do.
But you attended the trial. You were here every day, right?
I did.
Miss Thompson put you in a new suit every day from her husband, right? She put makeup on you, right?
I did.
Yeah.
You're right.
I mean, you sat here, you listened to the witnesses, you took notes, right?
I did.
You were engaged in the trial, right?
I did.
You're pulling on their suit coat and asking them questions. You're interacting with them. Jonathan Reeves, your cell phone expert, told the jury Zach Adams' phone was pinging off of the Parsons cell tower at 11:16 in the morning. Remember that?
That's right, along with Shane Austin and Dylan Adams.
Right. We're all in Parsons.
That's right.
We're all in Parsons at 11:16 in the morning. The jury heard it. They didn't seem to care much about it, did they?
The jury heard a lot of things, a lot of lies.
Right. Everybody was lying, weren't they?
Well, I wouldn't say everybody, but there was a lot of lies told in that case, in that trial.
Mhm.
Lots of lies.
Let me ask you about the trial a little bit more. You mentioned that if I had just known that I had the opportunity not to testify, or to testify, I would have done that. I would have done that. I'm sure you've seen this, and we'll talk about it in a little more depth in a minute. There's a document, a series of documents that your lawyer's team put together titled Zach's Stupid Mouth. Remember that? Did you ever see that?
No.
It outlines everything that Ms. Etu has just talked to you about. In addition, everything else that you said to anybody with ears between April 13th, 2011 up to today. Because you're still talking about it. But at the trial, after the state rested, right? And Judge McGinley looked to your team and said, will there be any defense proof? Does your client want to testify? Remember that?
What was the question again?
Do you remember being asked if you wanted to testify at your own trial?
I did.
Okay. You're on trial for the rape, murder, and kidnapping of Holly Bobo. The judge asked you if you wanted to testify. Did you answer the judge right away, or did you talk to your lawyers about it?
I believe I answered right away.
You just blurted out an answer.
I said no. I was advised by my lawyer not to, and that's what I did.
Okay, all right. May I approach, Your Honor?
You may, you can pass it to the vote.
Your Honor, may I see what is being
The
presented?
moment here at the trial, it's page 2,539 I don't know, at the bottom. There you go.
Thank you.
You recognize this?
Your Honor, would you like the transcript? We have a copy of the transcript for the court if you would like to follow along.
I'll be all right. You got any objections to speaking?
No, Your Honor.
Let's go ahead and check it in, but have it Exhibit 116.
Do you recognize Judge McGinley talking to you?
Yes, ma'am.
You sat in that stand, didn't you?
All right, very different tone from the direct examination to the cross, which is typical, but here you don't have a jury, so it's let her out.
Yes.
Doesn't matter, you can battle away.
She is really going after him, the prosecutor.
Wants to get under his skin.
Oh,
right?
yeah.
That's a tactic that we see play out, and we'll get a break and see more of it play out. Will he crack? Will he fight back? He's already getting a little agitated. We'll see as Zachary Adams continues to testify. Hoping for a new trial. Plus, Georgia Lanz, judge still thinking about it.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
It's a massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage begins December 1st on Court TV.
All right, let's head back to Tennessee now. Convicted killer Zach Adams taking the stand in his bid to get a new trial in the death of Holly Bobo.
The 20-year-old nursing student disappeared from her home in 2011. 6 years later, Adams was found guilty of kidnapping, raping, and murdering her.
He was sentenced to life in prison, thanks mostly to the testimony of a man named Jason Autry. Now, years later, Autry said he made it all up on the stand, and Adams is back in court saying, I want a new trial.
Let's get you back into the courtroom now. More of the cross-examination of Zachary Adams.
You sat in that stand, didn't you? You remember?
I don't recall sitting in the stand. I think I stood up over there at the table.
Swear you in?
I don't believe I was sworn in.
Yes, you were. Read it. You were sworn in, and you were sworn to tell the truth. The whole truth, and nothing.
Okay, I see that right here.
By virtue of, what else did this be marked as an exhibit?
I did. I marked it as Exhibit 160.
By virtue of the Constitution, we all have certain rights. One of those rights is you can't be compelled to give testimony. You were present when this is the judge talking to you, right? Not to Ms. Thompson, not to your mother, to you. You were present when I read that to the jury at the outset. Said if you do not take a stand to testify, that they can draw nothing from that that's constitutional right. Also, you have a constitutional right to give testimony if you wish or desire. You can take a stand. If you do, you would be subjected to cross-examination, and your credibility would be judged by the jury by the same standards I've already charged them. This is your decision, okay? Again, this is the judge talking to you. Your big moment.
Miss Wyrick.
You can make it having consulted with your attorneys. Again, this is the judge talking to you after you've been sworn to tell the truth. I would expect you to consult with your attorneys, but this is not their decision. This is your decision. You're standing there between two of your attorneys. Mr. Gonzalez came on the case late, but you've had ample opportunity to discuss this with Mr. Simmons and Ms. Thompson. Is that correct? That's the judge asking you. Is that correct? You know what you said? Yes, sir. Having said all of that, is it your election not to give testimony? Again, this is the judge asking you. Yes, sir, that's right. Correct. The judge goes on because the judge wants to make sure this very important decision is being made freely and voluntarily, without any pressure, without a lawyer saying, oh, no. You ain't getting on that stand. So the judge says to you, are you doing this freely and voluntarily? You said, yes, sir. You don't feel you've been pressured either way? This is the judge asking you again. No, sir. The judge goes on because it's that important. To give or to not give, you cut him off. You were so ready. No, sir. No pressure. No, sir. This is your decision. The judge is asking you again. This is your decision. Yes, sir. All right. Want to address anything further? Here's your open mic moment. Do you want to address anything further?
Absolutely.
No, sir, I do not. And that was the end of it. And then your team began putting on your proof in the trial. What was the defense in your trial? Do you remember?
I was innocent.
Right. What was the defense? What was the strategy? Who committed the crime?
Mr. Britt.
There you go. Terry Britt was the strategy. And the defense was built around that, correct?
I also want to say my mind was already made up about the testifying before the judge asked me all this. My mind was made up the minute that I promised my mom and my cousin that I wouldn't testify. There was nothing that was going to change that.
So you're either lied to Judge McGinley when you were under oath. You didn't tell Judge McGinley anything about your mom and your grandmother pressuring you. So you either lied to Judge McGinley on that day, or you're lying to this judge today about it. Because that never came out of your mouth, did it?
That didn't come out of my mouth, but my mind was already made up. Okay. My mind was already made up.
You never told the judge that, though, did you?
No, I didn't.
Okay, all right.
I didn't. There was a lot of things that I didn't realize at my trial, things that I know now. There was a lot of things. I was totally unprepared. I had no way to access law books or anything. There's a lot of things I didn't know that I would have did different. There's lots of things
that you would have done differently.
Yes.
Right.
Yes. Absolutely. Right. I would have demanded to go through all the discovery. I would have demanded it. That's one of the key things. What if there's something in there? My lawyer don't know if there's something in there. I mean, that's.
Well, let me ask you this: how many times did Miss Thompson come to meet with you?
I don't recall, Miss Wyrick. She came a lot. She did.
She worked hard on this case. Almost 4,000 hours. Do you know that? Almost 4,000 hours of time that she billed the state of Tennessee for, which is probably an underestimate of the time. I would imagine she probably put time into this case that she didn't bill the state for. In addition to that, your family paid her $50,000, right?
I believe it was 55.
All right. She put a lot of work into this. How many times did she come see you? 10, 20, 30, 40?
She came a lot.
Give us an idea.
50.
50 times.
I would say, yes.
Judge, on a speculation.
I don't recall. Like I said, I don't recall how many times. I didn't count. I didn't mark it.
He's giving us an estimate. It's a lot. We know it's a lot.
But every time she came, she wouldn't. A lot of times we would just be going through the discovery, going through stuff.
Well, I thought you just said you never saw the discovery.
I didn't see all of it.
Did she ever
There's
call
4 terabytes worth. I didn't see all of it. I'm not sure she looked at all of it.
Did she ever call you on the phone? Did you ever call her on the phone?
We did.
Okay, so you had in-person meetings, you talked over the phone. Every time you had a court setting, you were with her, correct?
We did, and when she did call, when we did talk, we didn't talk. She advised me not to talk about the case on the phone. She was very leery. When I was at Chester County Jail, I remember they would let me call her, but they would carry me to there's a little room in there, the same room when she would come to meet with me. It's the same room they would put me in. And when I told her about that, she said, "Well, from here on out, don't talk about nothing on the phone. We think this room may be wired or something."
Sure. So she didn't want you talking there. Right. So she came to see you many times. She also...
All right, this is getting a little contentious between prosecutor and now convicted killer Jack Rice is up in St. Paul, Minnesota. We don't get to see this very often, Jack. It's, a post-conviction relief motion hearing that he wants a new trial, and there is a little there with the recantation from the other witness. What's your overall take? How's he doing? And I just would love to have your thoughts.
Yeah, well, good morning. First of all, this is an incredibly high standard. This is incredibly hard to do because once you get a conviction, what you find is that the system wants to keep that conviction in place. And more importantly, when a judicial panel, when any relief is looked at, they always want to try to find a way to allow that jury decision to hold. And what's fascinating about this prosecutor is she pushes a certain direction because she's looking for a particular response. All of a sudden, he starts arguing about ineffective assistance of counsel, when in fact, that's not what this is about at all. What they're saying is that there is new evidence in this case, and he's claiming the new evidence. He's starting to get rattled. That seems clear to me. And she's actually very effective, extraordinarily aggressive, by the way, but effective in terms of driving him down the paths that she wants to drive him down.
Yeah, I mean, she's trying, Jack. So the standard, when we talk about the defendant's burden here for the post-conviction relief, in order for the judge to grant it, it has to be that new evidence would have had to have a material effect on the outcome. And we have here the recanted testimony. That's what they're talking about. We also have on the stand him talking about being at the ATM when this murder was taking place. So you have some stuff. Defense counsel definitely has a lot of stuff to work with here.
Yeah, you're right. You're right. I mean, that's the difference. They're trying to say, but for this conviction never would have taken place. This new evidence, this information that was never provided to this jury would never have found me guilty of it. And so therefore, I deserve to get a new trial because justice demands it. But what you're going to see on the other side of this is you're going to say, with all of the evidence that was presented, with everything that the jury saw, with everything that everybody did, was there a way for this jury to find him guilty anyway? And I think that's what they're really going to be looking at. And I think the difficulty that he faces is that this standard is very difficult to say, but for all of this, I would have been innocent. That is a very difficult standard to meet because essentially, that's what he's arguing.
Yeah, I mean, he's already made it farther than most. You know, he's not sitting in his prison cell. He's actually testifying in front of a judge, and he has an opportunity. So, but to your point, it's a long climb ahead as he continues down this path. We'll get a break. When we come back, more from Adams. He testified that he was scared of Jason Autry, the co-defendant, who now has recanted his testimony. We'll head back to Tennessee in just a moment, but first, a quick check-in on Georgia, where closing arguments wrapped up earlier this morning in the stranger home invasion murder trial for Matthew Lanz.
Lanz is facing multiple charges, including murder and assault, for allegedly killing Justin and Amber Hicks inside their home back in 2021.
During closing arguments, Lanz's defense attorney talked about what they said was a lack of evidence in the case. Take a listen.
They didn't find anything that would tie Matthew to being inside that house. As a matter of fact, as the court heard, the shell casings were tested, and there was no DNA of Matthew found on the shell casings. So nothing that was found at the scene would tie Matthew to the interior of that scene. As a matter of fact, the only DNA that came off of the shells was the child, Jacob's, which we could see that most of those shell casings were probably moved around by him. We saw in the bathroom that the toilet seat was up. There was some toilet paper on the floor, and it appeared to have other items there. When I asked the officer, is it possible that he could have flushed those shells down the toilet, the officer indicated that might be possible. Shell casings were never found in Athens or any other place.
Now, this is a bench trial, meaning the judge will determine Lanz's fate. We'll get you into that courtroom as soon as there's a verdict.
Back now to Tennessee, where convicted killer Zachary Adams is in court hoping for a new trial.
Adams was found guilty in 2017 for kidnapping, raping, and killing 20-year-old Holly Bobo, who had disappeared from her home 6 years earlier.
Now, during the trial, a man named Jason Autry testified that he witnessed Adams kill Bobo. Now, years later, he says, I made all of that up. Adams' defense is appealing his conviction based in part on this new information.
Let's get you back inside the courtroom. We are listening to Zachary Adams on the stand.
So she came to see you many times. She also sent people to come see you, correct?
She did.
Mitigation experts that came to see you, right? Remember Lee Norton? Who was Lee Norton?
The one that did the IQ test and all that?
Okay. Jim Simmons, did he come see you?
He did.
All right. Did Jerry Gonzalez ever come see you?
I don't specifically recall. I think he might have came once. I don't really recall.
How many times did the mitigation specialist come see you?
I think we met once with Jim Simmons, and then she came back another time and gave me the IQ test.
And there was a team of investigators working on the case, right?
I remember two investigators. I remember two. I think there was two. Jim Simmons had a investigative team, and Jennifer had one, but it was like two investigators.
They ever come see you?
They did. They came with Jennifer and Jim.
And so I'm certain, correct, that in these conversations and these meetings, when you met with Ms. Thompson, did she take notes? Was she writing anything down? Was she just on her cell phone?
She took some notes.
Okay. So in the course of these interactions, did the investigators take down notes?
I don't recall. I believe so.
Okay. What about Lee Norton? Lee Norton take notes?
I don't remember much. I can't really recall Lee Norton. I know we did the IQ thing. That was with the blocks and all that stuff. I thought that was kind of...
But it's your testimony today that you told all of these people, I couldn't have done this because I was with Shane ODing on Xanax, right?
That's the truth.
Okay. And you told all of those people, I couldn't have done this. I was with Shane ODing on Xanax when Holly Bobo was abducted, raped, and murdered, right? That's what you told them.
Shane and Dylan was with me.
Okay.
They was with me.
Right.
So we was
At
in,
what time?
well, like you just said, 11 o'clock, we was at the ATM. So that truck that you just showed, that's us pulling the ATM backwards.
Right. Okay. But you told all that to Miss Thompson and to Miss Norton and to Jim Simmons and to the team of investigators. They all knew there was no way.
Like I just testified to, there was things that I don't remember about that morning. I don't specifically recall going to that ATM until some later on.
Okay. Do you remember telling? Well, let me ask you this. Did you remember reading or seeing from Ms. Thompson a report from one of the mitigation experts there are problems with using his mother as mitigation because Zach shot her? Remember that? I know a minute ago I wrote it down because it was such a creative description of a shooting that somehow your mother's leg accidentally got in the path of a bullet that you accidentally had in your possession. I think I'm not getting it accurate, but you shot your mother.
I did not shoot my mother like you're sitting here saying. I operated a firearm in a reckless manner. Rule number 1 of hunter safety: you're supposed to always, any weapon, you're supposed to treat it like it was loaded. I treated that firearm, a pistol, as it was unloaded, and it went off and it struck my mother in the knee. I did not voluntarily shoot my mother like you're sitting here, like you're trying to explain to everybody. That did not happen.
Trying to explain anything, Mr. Adams.
You're trying to make it like.
No. What I'm trying to do is get to the truth for the judge and for this court. And you're well versed in the use of guns, aren't you?
I am.
You've been handling guns since you were about 8 years old, right? When your grandfather taught you how to handle a gun and how to shoot deer.
Probably before that.
Okay. All right. So you know about all that.
Yeah.
You told the mitigation or the investigative team that came to see you that you've known Jason Autry for a long time, right?
I believe I just testified to that.
Right. You never told the police that, though.
Yeah, I never told the police that. I was scared of Jason.
Okay.
Jason's not a person that you're just going to tell the police on.
I'm not asking you, why didn't you tell the police that Jason Autry was with you at the river when you murdered Holly Bobo? Why didn't you tell the police Jason Autry is my best friend and we text and talk to each other on the phone every day? You never said that to the police, did you?
I never tell the police a lot of things.
Okay. In fact, you told Eva Pilgrim with 2020, I wasn't with Jason that day.
I don't recall being with Jason that day.
You just testified that you were with Jason that day.
I was, but I don't, there was no specific, I was with Jason so much. There was nothing we did that morning like we didn't catch a big bass. There was nothing specific about that morning to make me remember. Like those phone calls you just went through, I'm sure they happened, but I couldn't tell you what we talked about. There was nothing specific that happened that morning that stood out. I'm sure I made every one of those phone calls. I'm sure I made every one of those texts, but I can't tell you what we was talking about. I'm sure it was about drugs or something I guarantee it was about drugs. It's the only thing it could have been.
Coming up, things get heated, even more heated, when Adams is questioned again about his alleged alibi for the morning Holly Bobo was killed. That's next.
You have to punish him, you have to kill him for a few $100?
You don't touch fire and expect not to get burned. My goal is to embarrass you. My goal is to make you suffer. My goal is for pain. Make sure that you remember me for the rest of your life.
You weren't feeling any sympathy.
If I'm being honest now.
You kill a man for acting like a junkie when you're the one turned him into a junkie.
Interview with a Killer season finale, Saturday night at 8 Eastern and Pacific, only on Court TV.
All right, let's head back to Tennessee. Convicted killer Zachary Adams is in court for a post-trial hearing.
Adams was found guilty in 2017 for kidnapping, raping, and killing 20-year-old Holly Bobo, who had disappeared from her home 6 years earlier. Now he's hoping to get that conviction overturned.
Let's go back into the courtroom now. We've been listening to Zachary Adams on the stand, and it's cross-examination that the prosecutor's trying to get under his skin.
Do you remember how many times you told your lawyers, I just want to go to trial. I just want to go to trial?
Absolutely.
They wanted you to plead guilty.
I'm innocent of this. Absolutely. I don't care if death penalty's on the table or not. Absolutely. I'll to my dying breath, I'll be innocent. And that's the truth.
In all of these interviews with the investigators, when did you ever tell them, I was with Jason Autry that day?
Like I just said, I don't recall being with Jason that day. I was with Jason so much. Ma'am, we did so many drugs. Days would run together. Jason hung out at my house so much. We was together all the time. All the time.
Then why not tell the police that?
Two or 3 days before April 11th or April 13th, 2011. Look, 2 or 3 days after. We talked all the time. All the time.
Then why not tell the police that? Do you remember telling investigators that people steer clear of Jason and I when we're together? Most people know we are up to no good. Remember telling them that?
That's the truth. Most of the time me and Jason was together, we was up to no good. We was usually getting high or going, he was usually trying to steal something.
What kind of car did Jason drive back in April of 2011?
PT Cruiser, gray, 4-door.
Did he come to your house later that day before y'all went over to Dottie's?
He did, yeah, he came that day.
So you did see him later that day?
I did.
Okay.
Yeah.
All right, y'all went to Dottie's together, and you're both covered in blood, is what your brother and Shane told the police. You both had blood on your clothes.
That's a lie.
That was, of course, that's a lie, yeah. And that's when y'all got in the fight, right? You and Shane got in the fight there.
Yeah, but what? So he just pulls up my house. He got blood all over him. We're just gonna go go about our daily business with just blood all over. That makes no sense whatsoever.
There's a lot about this that doesn't make much sense.
You're right. You're absolutely right. Like those ATM videos. If we had those ATM videos of that day, you would see Shane Austin, you would see me in the driver's seat, and you see my brother in the back seat. But where are they at?
Right.
If we could get those, if the TBI would have did their job and got that, we wouldn't be here today. Promise you we wouldn't be here today.
Jury heard that you were in Parsons at 11:16 in the morning. The jury heard that from your own expert.
Miss Wire, of course they heard that.
Do you know what time Holly Bobo was abducted?
I don't.
7:50 in the morning on April 13th, 2011. So your defense team, you filed a notice of alibi, didn't you? You and your lawyers? Remember who your alibi witnesses were? Do you remember who you told the court your alibi witnesses were going to be in a written motion?
I think it was, no, I don't recall.
Dick Adams, Dylan Adams, Shane Austin,
right,
and Rebecca Earp.
All the people that I seen that day.
Right.
All people I made phone calls to that day. Everybody you just stated, I was talking to that day. Everybody you just stated, every one of those names you just stated that I talked to on the phone that day. Right. Every one of those names that I seen that day. Me and Dylan and Shane, we was all together that day.
Did any of those people, who of that bunch saw you at 8 o'clock in the morning on April 13th, 2011?
Nobody. Well, nobody.
All right. So on April 13th, 2011, much later in the day, after you've gotten into a fight with Shane at Dottie's, your grandfather calls 911. Not once, but twice. On April 13th, 2011.
That's correct.
The jury heard that, right?
That's correct. If I'm not mistaken, he said he's trying to get a gun and a vehicle. Well, why was I needing a vehicle if I had the white pickup like you said? That makes no sense whatsoever. And I believe you said it yourself yesterday. If I had access to a vehicle, why was I needing his vehicle?
Maybe you were trying to get out of town fast because you
That's not the truth. It's because I didn't have a vehicle.
And murdered Holly Bobo.
It's because I didn't have a vehicle. That's why I was trying to get his van.
See if you recognize these voices.
All right, Jack Rice, they're going toe-to-toe. The defendant's very adamant he didn't do this.
Yeah, I mean, he keeps coming back. I mean, there is power in consistency. Of course, the weakness is the inconsistencies that we saw in the original trial back in 2017. If we think about what the prosecutor is talking about is all of these alibi witnesses, the theory that they went with and what it meant, and the question you start asking yourself as you're listening to this is, well, wait a second. If you didn't know what the answers were, why weren't you telling your lawyers that in the first place? If you're saying that you were with one person and you were with somebody else, why weren't you following that line? Instead, what it feels like is that story didn't play. That story didn't hook in the way that you wanted it to hook with this jury, and so now you're coming up with a different story. You may not like the outcome, but guess what? The facts don't change, and yet you're trying to make an argument that they are. I mean, that's really where the prosecution continues to go. It's actually fascinating, though, when I look at this big picture, because during the last segment, we were talking a bit about how far this man has actually come in terms of sitting in front of this juror. Normally, you don't even get anywhere near this. You're going to see this on an appellate level where you're arguing certain things or you're trying to argue to get a new trial. Normally, you don't get to this space whatsoever. So the fact that the court is entertaining this and allowing him to take the stand himself and having his trial team, this appellate team, come in and argue that it's a different answer and that there is new evidence really does give some credence, at least a little credence, that he has something here that may be enough for that new trial. At least that's what his team, that's what he himself is asking for.
Jack, we have seen the prosecutor really grill him about many things, including him not taking the stand in his previous trial, claiming that he was lying to the judge about things and not being honest. You know, I don't know. I think she went at him a little hard on that. Not that it's going to really have an impact on the outcome and the judge's decision, but, you know, he did not have to take the stand. He went on the advice of his counsel, and his mom didn't want him to take the stand, and she just was really trying to make it seem like he's just a big liar. What did you think of that?
Yeah. Oh, you're right. And actually, I would agree. If we think about what she is doing, the prosecutor seems to be making the argument that because you didn't make the stand, because you didn't take the stand, because you didn't testify, somehow that means that you weren't prepared to tell the truth, or that somehow that means that you were guilty. And the thing is that's not the standard. The standard in a case like this is really, it's proof beyond a reasonable doubt, but he has no obligation, no burden to take the stand, nor to say anything whatsoever. The entire obligation is upon the state to prove that he did this thing, not for him to come back and say what he thought the answers were. This is a circumstance where sometimes I've seen prosecutors argue that this was unrefuted. That's not the case.
Yes. Good afternoon. Again, I am Judge Sonia Brown, the presiding judge for the trial of the state of Georgia versus Matthew Scott Lanz, 22-900-922. We are present here in the open courtroom. President of the court, the clerk, the court reporter, Mr. Lanz, he is represented by Attorney Jimmy Berry, and the state is represented by Assistant District Attorneys Green and Horowitz. In the Superior Court of Cobb County, state of Georgia, the state of Georgia versus Matthew Scott Lanz, defendant, criminal action file number 22-900-922. Non-jury judgment after bench trial. Defendant having waived his right to trial by jury, the parties having consented to a bench trial before the court, and the bench trial having commenced at November 17th, 2025 at 9 a.m. Now, therefore, after considering the evidence admitted during the bench trial, the parties' arguments, and the applicable law, the court finds as follows. As to count 1, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 2, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 3, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 4, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 5, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 6, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 7, home invasion, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 8, aggravated assault, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 9, aggravated assault, The court finds the defendant, Matthew Scott Lanz, guilty. As to count 10, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 11, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 12, cruelty to children in the second degree, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 13, tampering with evidence, the court finds the defendant, Matthew Scott Lanz, guilty. This 20th day of November 2025, signed and affixed with my signature, Judge Sonia N. Brown. Would you all like to take a look at the form?
No, Your Honor.
Right, Madam Clerk, if you would please enter this non-jury judgment after bench trial into the record of the court. All right, I will hear from the state of the defense regarding sentencing.
Your Honor, we have talked, I know that the state has quite a large number of people that want to speak. I think it probably would be wise to start that in the morning. So we can get through with it tomorrow.
State.
We don't have any objection to that. Thank you, Your Honor.
All right, so we will stand in recess until 10 a.m. tomorrow morning, in which time both the state and the defense will have an opportunity to present arguments and any statements from any victim impact statements or statements in mitigation on behalf of Mr. Lanz.
Thank you, Judge.
Right, we'll stand in recess until 10 a.m. Oh, one moment, please. Court is still in session.
Your Honor, just for the record, and I apologize for not putting this on the record prior, but as for your deliberations, the following exhibits were not provided to Your Honor. That was State's Exhibit 670, an ATF crime lab report, State's 671, another ATF lab report, State's 917, which was the Google search history, State's 607, which was the ZevTech OZ9 of the defendant's gun. State's Exhibit 468 was not an exhibit. It was never tendered, it wasn't missed, it just was never, that number was never used. And then finally, of course, we did not provide Your Honor with Master Drive A, which contains State's Exhibits 5, 7, 460, 462, 463, 464, 465, 466, 467, 469, 470, 471, 472, 473, 474, 481, 685, and 686. Thank you.
We agree with that.
Right, and all the evidence has been brought and placed back in court.
Thank you so much.
Right, we'll stand in recess until 10 a.m. tomorrow morning.
Thank you, Your Honor.
Thank you. Deputies, you do have a status hearing, well, Floyd, I guess we're not fast, I have a status hearing at 1:30 on a separate case.
Okay.
Okay, so we'll be in the session at 1:30, but it's on a separate case.
Yes, ma'am.
Thank you.